Hi folks, this is Sharik. I'm the South Asian attorney. Today I want to talk about adjustment of status versus consular processing. As an applicant for a green card, you'll have to go through a multi-step process. Regardless, the final step in all green card petitions is choosing between adjustment of status or consular processing. Each option has its advantages and disadvantages. Therefore, you should consider them carefully before starting the green card process. You must be physically present in the US when submitting the AOS application. You can only apply for consular processing if you're outside the US. Your entry into the US must be lawful, which means that at the time of arrival to the US, an immigration officer should have admitted you at the airport and promptly issued you an I-94 card. Most individuals now receive electronic I-94 cards. Following lawful entry, you must have maintained a non-immigrant status in most cases. Unlawful work or overstaying your admission period will render you ineligible for AOS unless you're an immediate relative of a US citizen. One of the first steps in a green card process is filing for I-130 or I-140 petition. Once this petition is approved, you can proceed to adjustment of status stage. However, your priority date should be current before you can reach this stage. But as an immediate relative of a US citizen, you will not have to wait for your priority date to be current. You may file for the I-130 petition and the adjustment of status applications simultaneously. Similarly, as an employment-based applicant, you may file the I-140 and the adjustment of status application simultaneously. That is, if your priority date is current. You can verify your priority date on the visa bulletin published by the Department of State. You can also get more information on the visa bulletin in my podcast, How to Read a Visa Bulletin. Applicants for adjustment of status must be admissible to the United States. For more information on who's not admissible, check out my podcast labeled Inadmissibility. Your sponsor will file the I-130 petition for family-based immigration or the I-140 petition for employment-based immigration. The approval of these petitions establishes the relationship between the sponsor and the beneficiary. However, it does not provide any immigration status or benefit. For family-based immigration, you'll have to have your financial sponsor complete Form I-864, which is basically the form for affidavit of support. A financial sponsor removes the new immigrant's need to rely on public benefits. Therefore, the new immigrant uses certain public benefits like food stamps or Medicaid. The agency providing the benefits may require the financial sponsor to pay for these services. Most categories require you to have an approved immigration petition before filing for adjustment of status. However, as I mentioned above, immediate relatives of US citizens can file both applications simultaneously. After your application for Form I-130 is approved, you must file Form I-485, which is the application to adjust status. Two types of applicants may apply for adjustment of status, a principal applicant and a derivative applicant. What's a principal applicant? The beneficiary of an immigrant petition is called the principal applicant. Derivative applicants are family members of the principal applicant. Both the principal and the derivative applicant must designate which immigrant category he or she is applying under by selecting the appropriate box listed on Form I-485 Part 2. So each applicant must include the appropriate filing fee and the biometric fee. In addition, at the time of filing, you must submit the required evidence and supporting documentation. You can find more information on the evidence and supporting documentation on the USCIS website in the instruction section for Form I-485. After USCIS receives your application, it will confirm its accuracy and completeness. Then it will mail you a notice for your biometric services appointment at a local application support center. At this appointment, ACS will collect your fingerprints, photograph, and signature. USCIS will then schedule you for an interview. You must bring all originals of all documentation submitted to the USCIS with Form I-485. The originals should include a passport, official travel documents, and Form I-94. Keep in mind that if you change your address, you must inform USCIS within 10 days of moving to the new address. You should choose consular processing if you reside abroad, if you are ineligible to apply for adjustment of status, or you elect not to adjust status. Consular processing is mainly fulfilled by the Department of State, National Visa Center, and the immigrant visa sections at U.S. consulates or embassies. After USCIS approves your I-130 petition, it will transfer your case to NVC for pre-processing. Once NVC receives this information, it will create your case in its system and send you a welcome letter. With the information in the letter, you can log on to the Consular Electronic Application Center and manage your case. To make your payment, you will log into your case and click the Pay Now button under the Affidavit of Support fee on your summary page. You'll only be able to proceed to the next step after making the payment. Then you'll have your financial sponsor complete Form I-864, which is the form for Affidavit of Support, and submit tax transcript or a tax return along with Form W-2. A financial sponsor removes a new immigrant's need to rely on public benefits. Therefore, if the new immigrant uses certain public benefits like food stamps or Medicaid, the agency providing the benefits may require the financial sponsor to pay for the services. Then you'll complete the online visa application. This application is called the DS-260. You will also upload documents to support your visa application. NVC will review your submitted documents for accuracy. When NVC determines your documents to be complete and correct, it will schedule a green card interview appointment with the appropriate consulate or embassy and send you and your attorney an email containing a notice of the appointment date and time. Now you'll schedule a complete medical examination. You'll do this after receiving the appointment notice from the NVC. A panel physician must conduct this exam. A panel physician is a doctor whom the embassy has approved. The medical examination would also include a medical history review, chest x-ray, blood tests of syphilis, any required vaccinations, and physical examination. Now, the physical examinations will consist of examining the eyes, the ears, nose, throat, heart, lungs, lymph nodes, and skin, etc. Finally, on the scheduled date and time of your interview appointment, you will go to the U.S. Embassy or Consulate with your printed DS-260 confirmation page, where an officer will interview you and your family. The interview appointment letter will name all traveling applicants required to participate. Inside the U.S., you can choose between adjustment of status and consular processing. Although outside the U.S., you can only petition for consular processing. At adjustment of status interviews, USCIS permits attorneys to accompany their clients. However, at consular processing interviews, consulates do not allow an attorney presence. When applying for adjustment of status, you can apply for employment authorization document. This document will allow you to work in the U.S. as the USCIS processes your application. Additionally, you may want to apply for a social security number once you've received the employment authorization document. Now, if you wish to travel outside the US during the application process, you may apply for advance parole document. Without this document, you will not be able to re-enter the US. So employment authorization and advance parole documents are not available to you for consular processing. Processing time varies for each application. It takes an average of 8 to 14 months to get a decision for adjustment of status, and about 5 to 12 months for consular processing. Well, just keep in mind, COVID-19 has extended all these times significantly. If you want to convert from adjustment of status to consular processing, you will file Form I-824, also known as Application for Action on Approved Petition. If you want to convert from consular processing to adjustment of status, you will notify USCIS of the intent to change. The USCIS will send a letter acknowledging the change and requesting confirmation of your new choice. Then NVC will cancel the consular processing and transfer your file to the appropriate USCIS service center. Just keep in mind that this process will add several months to the processing time. So these days, the government filing fee for adjustment of status is $1,760. The government filing fees for consular processing is $1,200. Consider using adjustment of status if you live in the US and qualify for adjustment of status. And consider using consular processing if you live outside the US. Okay, as always, if you have any questions, you can call me, email me, or schedule a consultation on the website.